in the matter of the marriage of Benjamin H. Bravo and Monica O'Rourke Bravo. It's case number 2024 DM 309. Each party, Benjamin and Monica, appear by separate Zoom. Court conducted proceedings in this case on February the 12th. The court had a rather extensive set of docket notes, which I'll just read. At that time, Monica and Benjamin both appeared by Zoom, Benjamin from California. No action was taken on Monica's parenting time motion. Court notes that the registration of foreign judgment was not timely opposed. Kansas court has not made a decision as to whether Kansas accepts child custody jurisdiction to modify custody or parenting time orders. There's a California hearing. Judge Hamilton, Division 303, Fresno, California, set for March 18th, likely to be postponed on Dad's motion to have primary residential custody. For now, California maintains jurisdiction. Court order temporary to be provided to court for consideration and possible UCC-JEA conference and determination. Kids have lived here with mother since November of 2023. There's a move away order granted in California in September of 2023. Kids apparently in Andover schools. Her California restraining order expired and the review hearing was set for today. All right. After all that, we are where we are. I'm curious, what happened in California during the scheduled court proceedings for March 18? Monica?
Your Honor, there was an ex parte hearing at the beginning of March to request an extension for the trial in order for my lawyer to properly subpoena witnesses, since all of the witnesses for this case are in Kansas and require a little bit of extended time to get all of the subpoenas together for that. In light of that request, the judge postponed the trial or continued the trial to May 28th and 29th. There's 2 days, 2 whole afternoons set for the trial and on May 28th and 29th.
All right, Benjamin, is that your understanding as to what happened?
I wasn't present for the hearing, but there is a court date set for May, I think those 2 days right there. So.
All right. Monica, are you comfortable with the California court retaining jurisdiction and making the determination regarding any issues which may exist?
Your Honor, there's currently a motion and temporary order, which is what the California court is hearing in May. It is my understanding that because that order has already been, because it is already in process in the courts in California, that it's required that they finish this process for this current motion. If that is not the case, my preference would be to move the jurisdiction to Kansas immediately. If that is the case, that the current motion needs to be decided on in California first, then I would like to have the jurisdiction moved to Kansas following the conclusion of that motion.
Well, at that point, that could possibly change the physical custody of these children from Kansas to California, couldn't it?
Your Honor, that's actually not what the current conversation is regarding. The kids currently, I still retain, so let me back up. There was a temporary order put in place in January, and that in question at the hearing in May is whether or not that temporary order will become permanent, not a change to that, not necessarily a change to that order. Currently, the temporary order is that I still retain sole legal custody. We have shared physical, in which case the children's primary residence remains in Kansas, and Mr. Hernandez has visitation. It was simply just an increase in the amount of visitation, not that.
That's not the situation, Your Honor.
Let her finish, Benjamin, because I'm going to address you in just a moment.
Okay.
Go ahead.
The current order does state that the children's continued residence is in Kansas, and that the order is for them to fly to California 12 times a year, spending 71 days there. There's a lot of question around how it's written, and this is a big part of why I'm asking for the jurisdiction to be moved to Kansas, because the California judge wrote the orders in such a way that is very incongruent with Kansas laws and Kansas school districts and this Kansas school calendar. So the order will have to be changed in some way. It's incongruent and not reasonable to follow the way it's written, because it is written from a California court based on California schools, even though the kids are permanently residing here.
All right, Benjamin, thank you for your patience. What is your understanding of what's contested?
So when I filed the paperwork, the boys were being homeschooled, and so the court order, that's the temporary order that's in place right now, it has us exchanging every month. So I have the odd months and she has the even months. And so we split like summer times and spring break. That's in the plan as well. And I think they did that because they were in homeschool when I submitted the paperwork. And so this last year, Mr. O'Rourke decided to change up the school situation so that she could attempt to continue to maintain that custody. And so one of my boys is in permanent school now, and the other one's still doing temporary. He's doing homeschooling, the other one. So that's why both of my boys have been homeschooled most of their lives. So that's why the court order was issued in such a manner, because they haven't been around me the last few years like they were before. And so the court addressed that issue because they have been homeschooled. And so they were trying to give each one of us 50-50 physical custody so that we could both be present in their lives. And that's why the order is written the way it is.
I'm sorry, Your Honor. I'd like to clarify some of the inaccuracies that were just stated. The children were not in homeschool when the motion was originally filed. The children were enrolled, pre-enrolled in Andover schools back in May, and this motion was not filed until July. I'd also like to take your attention to the current order that Your Honor has a copy of. I sent it during our last hearing. Under the order 3.02 states, commencing with the date of the signing of this court order, the children shall reside primarily with the mother in Butler County, Kansas, except for the specific periods of time outlined below. And every other month order that Mr. Hernandez is speaking of is that he is to see them for one weekend every other month.
That is not correct.
There are additional inclusions in that order for them to spend time over holidays and during the summer as well, usually in a 1 week increment. But point number 3.02 does clearly state that commencing with the children's primary residence is still maintained in Butler County, Kansas. In which case I am currently asking for Your Honor to request jurisdiction be moved to Butler County, Kansas, since these children will, regardless of the outcome, this is the current order in place right now. The hearing is to contest that. The hearing coming up in May is to contest this order. I am the one contesting it. I'm not contesting that their residents continue to be in Kansas. I am contesting the amount of time and the methods that visitation continues. I do believe it is important for the kids to continue to visit their dad. It's contesting of it is simply that they like I said before, the way that the order is written is very incongruent with Kansas, the way the structures are here in Kansas. And that is my only request. And so if it is possible to have the entire motion move to Kansas and have your honor hear this order be contested here, that would be fine with me. And if that's not possible, then let the California court finish this portion and then have it moved here, because the judge has already ordered that the kids' residence has been and will continue to be Kansas.
That's not the situation. I'm not really sure what order Miss O'Rourke is reading, because that's not the court order that was granted. Because there's a 3-phase process to that new order, and I just completed the 3rd phase by visiting my sons in March of this month, and I'm supposed to get them every other month. So they gave us both 50-50 physical custody of our sons. I'm not really sure which order Miss O'Rourke is reading from, because that's definitely not the wording that I'm reading in the order at all. And this is one of the reasons why I think the Kansas court should not take this case over, because Miss O'Rourke has now been willing to co-parent every single situation that she can figure out to put up to make a wall between me and my kids. This is just another situation. By transferring over to Kansas, she's able to maintain that control, which she really likes. And she's able to put up just another barrier in between my relationship with my sons. I've completed what the court has asked me to do, and I'm asking the Kansas court to not take take jurisdiction of this case, because I feel like Ms. O'Rourke is just putting another barrier between me and my sons, and this would not be good for Ben and for Sam. They want to be around their father. They've specifically made that clear, and I hope that the Kansas court will understand that I have been present, and I will continue to be present, and I hope that the Kansas court understands that they need their father. That I'm just as important as the mom in this situation. If you see me and my kids interact with each other, you will see a completely different story than what Ms. O'Rourke has shared in the court hearings. She's been able to get away with legal maneuvering through the legal system to put up, to basically legally harass me in my parenting ability. And I'm asking the Kansas court not to take this situation over, because what she just read, that she said that there's 12 weeks, I believe she said, 12 weekends that I get to visit. That is nowhere in any of that paperwork. It says that I'm supposed to get them in May. She's supposed to get them in June. I'm supposed to get them in July. She's supposed to get them in August. I'm supposed to get them in September. We're supposed to split the holidays, the spring break, and the summertime. I'm not really sure which court order she's hearing or reading, because that's not the court order that I received from the Fresno County Court.
I have before me what's called a family law findings and order after hearing, apparently issued January 15 of 2025. It makes reference on page 2. Court will adopt the proposed custody and parenting time order as a temporary order until the contested hearing. See temporary order, child custody and parenting plan filed today's date. That is not attached to this order.
Right. I think
I
you
don't know
just
what
got the
it says.
minute hearings, or
Your Honor, I already, I did send you that order the last time we met. I can resend it again if you'd like.
This temporary order, which is supposedly an attachment to the order that I have?
Correct.
Okay, well, I don't have that before me. Let's put it that way. So I don't know how to resolve the dispute between the two of you as to what that temporary order says. It is what it is. And I'm not going to advise the parties to go against it. All right. When did the children establish residency in Kansas?
In November of 2023.
Okay.
And Your Honor, I did just resend that the actual orders that of which I was referring to when I read 3.02. And the portions that Mr. Hernandez is referring to are below that. In that same section, the children established residency in Kansas in November of 2023.
Okay. All right. November of 2023. And then Mr. Bravo Hernandez, you filed something in California to reinitiate proceedings there. Is that correct?
Right. Yeah, I've been in the process of
Do you know the date that you filed your motion?
I think it was like in June. I want to say June or May of last year.
Your Honor, it was in July, the end of July of
July.
2024.
Okay. One thing that is somewhat disturbing from a child custody jurisdictional standpoint is the court's finding that was apparently made in January that California is the home state
Right.
in this case and continues to have jurisdiction.
Yes, they said
I
that.
failed to see that the facts supported that finding. I don't know how that finding was made. Kansas was apparently clearly the home state of the children as of not only January of 2025, what that would have related back to sometime during the summer of 2024. Generally, there's a 6-month establishment of home state jurisdiction. If the children have lived continuously within a certain state for 6 months, that new state has child custody jurisdiction, what we call home state jurisdiction. And if there was no motion pending in California after the children had been in Kansas for 6 months, I don't quite see what the basis was for a finding that California was the home state, because it wasn't. The children weren't even living there.
I think we've been in legal proceedings since she moved away. To be honest with you, that's why the California jurisdiction they took effect.
Your Honor, that's not true.
I mean, I'm just getting
The
the
final
impression-
legal proceeding was the move away order when we moved out here in November of 2023. There were no pending legal proceedings until Mr. Hernandez filed the motion in July.
Okay, all right. I guess all I'm saying is I'm struggling with the concept that California is retaining jurisdiction as home state. Now, they may have some other basis for jurisdiction, but if they're relying on home state jurisdiction, I'm just not sure where that finding comes from.
Right.
And if that was the basis for jurisdiction, I'm not sure California has it. Kansas very well may. All right. Well, something that the California court has not contacted this court. This court has not initiated contact with Commissioner Hamilton pending the outcome of the March hearing. We now know what that was, and that was establishment of a trial date in May. I think this court is going to have to initiate contact with the California court. We're going to have to sort out this issue of child custody jurisdiction. Kansas law, and I'm quite confident California law would also support that there needs to be a conference between the two courts to determine who's going to take child custody jurisdiction over these children at this time.
Your Honor?
Yes, and I understand your position that you don't want Kansas to take it.
Right.
I get the impression certainly that Monica doesn't want California to keep it. So
that's because it's in her best interest. But I was going to ask you,
actually in the best interest of the children to have custody.
I'm just a minute. I'm going to give Benjamin the floor. Benjamin,
can you just clarify like what that court order allows me to do? Because I think one of the issues here is that we're not able to co-parent, and she is wanting to maintain control. And I just want to figure out what am I able to do in terms of seeing my kids, because that's really what I'm interested in. I'm not interested in dealing with Miss O'Rourke. I'm interested in just seeing my kids. And so I just want to make sure I maintain or understand what this court proceeding, what it allows me to do when it comes to seeing my kids.
Are you talking about Kansas or California?
No, the court order, that temporary order that was it was provided to us, because Mr. O'Rourke has a different interpretation of what it says. And according to what I've read is that I can see my kids in May. So they have to be flown out to California. And that's what the court was telling us, that we have to pay half of the ticket for the kids to be flown out. Mr. O'Rourke keeps on asking me to pay for me to travel out to Kansas every single time. And so I just want to get clarification from somebody that's in a legal situation, so that I have a good understanding of what, the next time I'm able to see my kids.
All right, well, I presume this order attachment, which I don't have before me, addresses that. As far as interpretation of it, I would suggest that your California lawyer interpret it for you.
Okay.
I'm not going to be giving either one of you legal advice as to what a California order says. There's no Kansas order which governs things right now.
Right.
That I can construe for you.
Okay.
But you're not proceeding under a Kansas order. You're currently proceeding under a California order.
Okay.
So I think I'll let your attorneys give you advice as to what your rights are or are not under this temporary order, which will be in effect at least until the end of May. Apparently, you have a trial date, and that's great. But that also establishes the time frame for me to get with the California court, because I have a motion here in the Kansas court, which we really can't further as long as California is entering what could be conflicting orders.
Right.
And I don't want you two to be confused about what state's orders to follow. So we need to clarify that.
Right.
And that will be this court's next step. Apparently it's, at this point, it's unavoidable that a UCC JEA conference will be necessary between me and Commissioner Hamilton. And I trust Commissioner Hamilton's still going to be the judge that hears the case in California?
Yeah.
Okay. All right. I don't know how often they shift those cases around. I don't know how their system works, but if that commissioner's still staying with it, then that's who I'm going to need to contact.
Okay.
All right. I think I probably have accurate addresses and email addresses for the two of you.
Yes.
Probably
Okay.
so.
All right. Well, when there's an outcome of that conference, I think it's going to be necessary for you two to be notified exactly what that result was. And this court will likely have to take the responsibility of issuing just an order, either confirming or declining jurisdiction here in Kansas. I am curious how the California court thinks they have home state jurisdiction. There may be some facts there that I'm not aware of currently.
Your Honor, under all of the dictates of the UCCJEA, Kansas is the state that would be required to have jurisdiction. I created a motion in California because I thought I needed to create it there to have jurisdiction transferred. And they denied that motion without prejudice, telling me that I needed to have that proceeding started here. That being said, just so you're aware, Judge Hamilton does have documentation regarding this process or this proceeding that I have previously filed in California. So she should have in front of her the reasoning and for the change in jurisdiction to be in Kansas. And again, I do want to note that I did send you the temporary order that is currently in place. And when you look over that order, my primary concern, again, in the best interest of the children, is that it has them missing school for extended periods of time. It has them flying back and forth between Kansas and California multiple times a year. Just creates a very unstable situation for the children. And so what I'm asking the courts, what I will be asking the California court, if if this motion continues in California, or if it's possible to have this motion heard here in Kansas, and abandon that trial to bring it here instead, and continue and have jurisdiction continued here so that the change in order could be heard here. Either way, the primary concern is that having a California court determine custody scheduling, visitation scheduling, when the children's reality is here in Kansas, and it is very, very different. I was a teacher there, I was a teacher here, and they're very, very different places. Just in the best interest of the children to have long-term, we have 7 years left, but who's counting? But longer term, to have the Kansas, a Kansas jurisdiction so that it can be responsive to what their needs are as they develop and grow here.
Your Honor, can I say something?
You may.
Ms. O'Rourke pretty much has limited my amount of time that I can see the boys. But basically, her preference has always been that I be placed on supervised visits and that she have full custody. That's always been her preference. It's always been limited. This is basically another way of doing that, is creating all these hurdles so that she can maintain control. It's not really about looking out for the best interest. If she was looking out for the best interest of our boys, she would not have moved them to Kansas, because they don't have any family in that area. She doesn't have any family support. She didn't look out for the best interest of our boys when she made that decision to move them to Kansas. You attend a soccer game. I was there a few weeks ago to watch my boys play soccer. Basically, there's no one supporting them at these soccer games. If they were to be here in Fresno where they're supposed to be at, my entire family would have came out for the game. And that's like uncles, aunts, nephews, and nieces. They would have came out to support my sons. I don't think it's in the best interest of my sons to live in Kansas, but that decision was not made up to me. And I think in the long term, my boys, it would be more beneficial for my boys to be around me because that time has been limited the last few years. Their mom maintains control physically, legally, and psychologically. She has alienated those boys from their father, and she continues to alienate Ben and Sam just in her ways. For instance, the other day I was supposed to have communication with Ben and Sam on Zoom. I forgot. Instead of her getting a hold of me, she decided that she didn't have any responsibility to communicate with me over talking parents. And so I sent her a message and I said, hey, I'm sorry I forgot to get on Zoom. I'm on Zoom now. Can you put the boys on? And I didn't hear any communication from her until like the following day. She didn't even respond to that message. These are the types of things that happen quite frequently with Miss O'Rourke. She has pretty much limited my ability to communicate with them. The only thing that she allows me to do is to communicate through the court order, whatever has been granted, and that's not necessarily in the best interest of our sons. Our sons, if you see them with me, they want my attention. Like, they want to communicate with me. They want to hang out. We play nothing but sports and enjoy our time together. Yeah, it's just been a big situation where Miss O'Rourke, she seems like she's doing it in the best interest. She communicates really well, but when it comes down to it, Miss O'Rourke is not doing what she's supposed to do as a mother. And me as a father, I don't think it's in the best interest of my sons to be away from their mother. I think they have that good relationship with her, but I don't think what Miss O'Rourke is doing in terms on the other side of not allowing me to communicate with them, not allowing me to see them, is in the best interest of our sons. And this might not be present now, but in the future, it's going to affect them psychologically. And Miss O'Rourke knows this because she's an educator, and she knows way better than what she's doing for those boys right now. And I hope that the Kansas court understands that this is more about control. This is not about actually looking out for the best interest of our sons. If she was looking out for the best interest of our sons, she would have never moved them out of Kansas.
Mr. Bravo Hernandez, do you think it's in the best interest of your boys to have their educational programs disrupted every other month by being sent to California and not being in school?
The thing about that is that they have been homeschooled most of their lives.
Okay, regardless of what the past was, isn't the current reality
Right.
There for this last school year, they've been in a structured school situation?
I don't think that it should be they should be disrupted, like the educational flow of their program should not be disrupted. I don't think that's in the best interest of our sons, to be honest with you. But the other side of that is I don't think it's in the best interest of our sons to move them to another state where they're going to be separated from their father. I was separated from my father at a very young age.
All right. I guess I'll stop you there, because if you're obviously we're not arguing custody of these boys
right.
today. That matter is not currently before this court. What is before this court is a possible issue as to whether this court should take over child custody jurisdiction and then hear this case.
Right.
With all of these factors being considered. If you're attempting to suggest to this court that Monica has engaged in reprehensible conduct that I should consider in declining of jurisdiction, nothing you've said in the view of this court constitutes reprehensible conduct. In fact, even the move away was done pursuant by court order in California. She sought proper permission from the court to move the children away. So right. I don't know that we've got a reprehensible conduct case here when it comes to whether or not Kansas should exercise jurisdiction. And I'm not going to decide the custody case before I decide whether I have jurisdiction to do so.
Your Honor, I might not have been able to prove it because I don't have an attorney that there has been reprehensible being dishonest in the court system. But in my opinion, the facts of the situation are a little bit deeper than this, and I know that you can't take it. You can only look at what's been judged on. But if you look deeper into the situation, there has been a lot of dishonesty in the situation to be able to maintain control, and this is what this case right now is currently about. Moving jurisdiction is just another control issue, and I don't think it's in the best interest of our sons, but that's not, I can only control what I can control.
Good. All right, the court will take the issue of Kansas child custody jurisdiction under advisement. It is the intention of this court to set up the conference with Commissioner Hamilton in California. We'll discuss the jurisdictional bases in California and Kansas and make hopefully an appropriate joint determination as to what jurisdiction is the most appropriate forum to hear any child custody or parenting time schedule disputes which currently exist between the two of you. And obviously with the best interest of these boys in mind.
Right.
So I'm going to set this case for review hearing prior to the California trial date. So I would intend to notify you by written order what the outcome was with my jurisdictional meeting with the California judge prior to this time. I just want to make sure I have a date on the calendar to work towards. The date, 28th and 29th.
Double checking those dates for you. Sorry. I'm sorry. It was the it is the 29th and 30th.
Oh, okay.
Yeah.
Right. I am looking at a date for review on Tuesday, May the 27th. I'll conduct it at 11:00 a.m. Kansas time. Which I think it'd be 9:00 in the morning in California, wouldn't it, Mr. Bravo?
Yeah, I had to do some adjustments this morning because I forgot you guys were two hours ahead.
Okay.
The 27th should work. You said the May 27th?
Yes, that's the Tuesday right after Memorial Day.
Yeah, that should work.
Okay. So it'll be 11:00 Kansas time on Tuesday, May the 27th. I think for simplicity purposes, we use the same Zoom numbers as last time, Mandy. Now that we've shifted to a different Zoom system, will we have to send another Zoom invite?
We can use the same one.
We can use the same one?
Yes, Judge.
Okay, it'll be the same Zoom numbers then? And we'll look at the case again based on then current circumstances, Tuesday, May 27, 11:00 a.m. by Zoom.
Thank you, Your Honor.
Until then, I hope that you two can work together in accord with the California orders in the best interest of your children.
All right.
Thank you, Your
Thank
Honor.
you, Your Honor.
We'll see you May 27th at 11 by
All
Zoom.
right, you too.
At this time, this case is in recess. We can end the meeting for